We seem to have had more than our fair share of issues that are affecting the branch already this season. We have a number of nominations, obviously, before us today, and there's the potential during the course of the day that we may ask a couple of people to come out of order and testify before the committee, but we'll start with the agenda as it's printed, and I will be consulting with Representative Lawler and Senator Kissel. Representative O'Neill, I believe, is out of the building on district business, and maybe showing up later, but we'll see what happens as the day proceeds. The first, I should also say, if you're a member of the public and want to sign up to testify before the committee, you're more than welcome to do that. There's a sign-up sheet by the door. We will take members of the public after we have had an opportunity to hear from all of the nominees. If a individual wants to testify before the committee, our standard procedure is that you sign up. You'll have 3 minutes to testify before the committee. At the end of the 3 minutes, there will be a bell that will let you know that your 3 minutes are up. We won't cut you off in mid-sentence, but we would ask that if you are going to provide that testimony and you exceed the 3 minutes, you wrap up your testimony as soon as practicable after that 3-minute period of time. If you intend to testify against a nominee, there is a potential that we would ask you to take an oath to submit your testimony before the committee under oath. And as is our practice in the Judiciary Committee, if you have something negative to say about a potential nominee, we would certainly afford that nominee an opportunity to retake the chair after all of the members of the public have testified, so that he or she could address any comments made from members of the public. We have also been provided with certain information by the Connecticut Criminal Defense Lawyers Association. I believe our staff has sent around an email to members of the committee letting them know that those materials were available in the Judiciary Committee's offices and available for inspection by members of the committee or by members of the public if they wished to see it. I would say that while we are always thankful to have input from members of the public and members of the bar with respect to the qualifications of a particular nominee, all information is welcome. Some information is, I guess, perhaps more welcome than others. And I say that because the submission of, and I'm just speaking for myself, but the submission of anonymous comments or observations about a particular judge, while welcome, don't at least hold a lot of weight with me. I think that in general, if somebody is going to provide information to the committee, they should either provide it in person or at least have their name connected with that information, so that the nominee can reply intelligently to anything that is included in information presented before the committee. Some of this may be some odd procedures for judges who are normally make sure that evidentiary standards are upheld in courtrooms, and while that's appropriate in the courtrooms, we in the legislature deal with a very different path of obtaining information, not always as reliable as judges have in their courtrooms, but we are more open to receiving information, and I guess you could say it goes to the weight, not the admissibility. But I do encourage anybody who has information that they want to present to the committee, I would strongly encourage you to attribute it to your individual name if you're going to ask members of the committee to rely upon that in any way. John, did you want to say anything? All right. So with that, the first nominee before the committee is the Honorable Thomas A. Bishop of North Stonington to be a judge of the appellate court. Judge Bishop. Good afternoon. Please raise your right hand. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Please have a seat. Your Honor, it's a pleasure to have you before the Judiciary Committee. I believe that, at least for me, this is the last go-round of judges that I've never had an opportunity to talk with at a nomination hearing. This is my 8th year, so it would be only logical that this group of nominees are my first time to welcome you before the Judiciary Committee. We'd be happy to have any opening statement you'd like to provide to the committee.
Thank you, and good afternoon, Chairman McDonnell and Chairman Lawler, Senator Kissel, members of the committee. I apologize to those of you whom I seem to be sitting alongside. I'm not quite know how to do this in the round. I appreciate this opportunity to appear before you to seek reappointment to the appellate court, and I certainly appreciate Governor Rell's nomination that brings me before you. By way of brief background, and I know you have several nominees to hear this afternoon, I live in North Stonington, where my wife Catherine and I raised our daughters Sarah and Cassie, both now young adults. After graduating from the University of Notre Dame in 1963 and spending 2 years on active duty as an Army officer, I attended Georgetown Law School, from which I graduated in 1969. For the next 25 years, I was an associate, then partner, and then finally managing director of the New London law firm of Sussman, Shapiro, Wool, Brennan, and Gray. Along the way, I started teaching at UConn Law School, where I was an adjunct professor for 20 years, first teaching courses in dispute resolution, and in the later years, a seminar on separation of powers with the focus on judicial independence. I was appointed to the Superior Court by Governor Weicker in 1994, and for the next 7 years had a succession of challenging and interesting assignments, including criminal, civil, family, and for nearly 2 years, the habeas docket in Rockville. My last Superior Court assignment was to the complex litigation docket. In 2001, I was appointed to the appellate court by Governor Rowland, a responsibility I have immensely enjoyed and for which I hope you will find me worthy of continuing. In addition to my work on the appellate court, I have been a member of the Criminal Justice Commission since 2001, and I have served in that time also on the branch's Evidence Oversight Committee, which I have now chaired for the past couple of years. That's a thumbnail sketch. Mr. Chairman, I'd be pleased to attempt to answer any questions that the committee members may have.
Well, thank you, Judge, and appreciate you your opening comments, and apologize. We're trying to get you to do a thumbnail sketch of what has certainly been a very productive and wonderful time on the bench. From everything I know about you, you've served the state of Connecticut extraordinarily well. And certainly think you will do so for another 8 years. I just wanted to ask you briefly, because it actually came up in the context of a decision that you authored on the appellate court, and just so if you're ever concerned that we don't pay attention to what judges are writing and saying, I wanted to ask you just briefly about an opinion you wrote with respect to the name of it was Bennett versus New Milford Hospital, and in that decision you pointed out something that perhaps the legislature should look at, and we're actually going to probably be taking you up on your suggestion, or on the court's suggestion, I should say, in that opinion relating to good faith certificates in malpractice cases. And I just want to ask you, as I understand that decision, there is essentially a higher threshold for, potentially a higher threshold for the good faith certificate for an expert versus the testimony of such an expert at trial. Is that fair to say?
I would say it's slightly different,
okay.
Senator McDonnell. Let me just say at the outset, I don't know if a motion for reconsideration has been filed in that case. I'd be pleased to talk with you about the opinion, but it could.
Well, let's talk about the process.
Obviously, that was a case of statutory interpretation. And the statute, as I read it, and as the panel, because we were, I believe, unanimous in that case, requires that the physician who signed the certificate have the precise same medical certification as the defendant. And so that doesn't necessarily speak to whether that person is actually qualified to give the opinion, but the statute is very clear that the person giving the opinion has to have precisely the same certification as the defendant. In that case, as I recall, the defendant is an emergency room physician, board certified, and the doctor who gave the opinion is a surgeon, board certified, not the same certification. There is a different statute that deals with who is qualified to testify at trial and to give an opinion with respect to both standard of care.
Excuse me, Your Honor. Could members of the committee and members of the public, if you have a cell phone, could you please turn it onto silent or vibrate so it doesn't interrupt the testimony before the committee? Please proceed, Your Honor.
Thank you, Senator. There's a different statute that deals with who is qualified to testify at the trial, that is, who can give an opinion with respect to standard of care and the causation. That statute doesn't mirror the statute that deals with who is qualified to sign the certification at the outset of the case. That statute permits one who is otherwise qualified to give an opinion and doesn't require that it be a person of the precise same certification. That was the problem in that case.
Practically speaking, why should the legislature care?
That's actually a question for
sort of rhetorical, but
but it's not a question that's appropriate for me to try to answer. I think it's appropriate. I hope that it's appropriate for the court to point out what some may perceive to be an anomaly, so that if there is a public interest in dealing with it, then the public interest will be met. But it's not our role to suggest how we think it should be changed, or even whether, because you may very well decide it's appropriate for the threshold to require precisely the same certification, because that serves a different function than the actual trial on the merits. You may make that decision. We thought it was appropriate simply to highlight an apparent anomaly.
And I certainly understand that the court is not going to make policy determinations, and I wasn't suggesting that I was looking for yours. I guess my question was, practically speaking, what would the day-to-day consequences be for a litigant in court, given that anomaly between the two statutes? What kind of difficult circumstances might arise that we as legislators should be concerned about, whether we choose to address it or not?
The route through which this case came to the appellate court was that it had been dismissed by the trial judge. That plaintiff is out of court. I don't know. I don't want to speak with respect to that particular plaintiff, because that gets into the case, and who knows if there's a petition for certification to the Supreme Court on that case. But if someone's out of court, and if they're beyond the statute of limitations, then they could be out of court permanently. So it's a significant impact on a plaintiff.
Now, let me ask you, given one of the things that we are looking at in the legislature this year is with respect to the judicial branch, are the pressures that are being brought to bear on the branch, given the financial difficulties that we in the state are all experiencing. From your vantage point, have you seen any changes in the day-to-day workload or burdens that are being put on the appellate court? Because we have a number of judges who are superior court judges and senior judges and judge trial referees who we're going to be able to talk to about the front lines, if you will. But from your vantage point, as the only appellate jurist before us today, have you seen any significant challenges in your day-to-day role as an appellate jurist because of the state's budget?
No, not on the appellate court. I know there's been a significant impact in the Superior Court. I know there's a great concern about marshals in the Superior Court, and I share that concern, having been a trial judge for 7 years and having been in courtrooms that were quite vibrant and where security was an issue. I know that's a significant problem. We don't share those problems. Our court time, as you know, is a very small percentage of our work effort. we need marshals because the public comes, and we do have inmates, and we have security needs in the building, but those needs are being met, Senator.
Well, thank you very much. Senator Kissel?
Thank you very much. Great to see you, Judge Bishop.
Thank you, Senator.
Along the lines of what Senator McDonald asked regarding the economic recession and its impact on the judicial branch, the other sort of major wave that I see impacting the practice of